So welcome everyone. For those who don't know me, I'm Dr. Geoffrey Whale. I'm Technical Director for the Forum of Insurance Lawyers. So a big welcome for this event on the consumer duty, the FCA consumer duty. And really the genesis for this event really was going back to discussions within a number of our sector-focused teams, specifically our professional indemnity team, looking at the future horizon, looking at the different people in the claims distribution process and thinking about potential claims on the horizon. So we thought it would be an opportune time with the duty coming into force at the end of this month to arrange an event. And I'm really grateful to 39 Essex Chambers for agreeing to host this event today, and to our two excellent speakers, Charles Corey Wright, who's Joint Head of Chambers at 39 Essex Chambers, and Jonathan Drake, partner at DWF, for speaking to today. So I'm not going to speak for long, just to do a little bit of housekeeping. I've been asked to read out an emergency procedures announcement, so I shall do that. In the unlikely event of an emergency, an alarm is operated. Please evacuate the building immediately via the staircase to the left of the lift bank. Do not use the lifts. Make your way to the meeting point, which is by opposite Chambers main entrance next to the higher binds. Do not re-enter the building until you are informed it is safe to do so. So with that adieu, just all about the format for today. We will be recording the main speakers, but when we get to the Q&A, we won't be recording that, and Chatham House rules will apply. For us likely to produce a brief update on the event, and I will be circulating the slides and the recording to anybody who's registered for this event, and we'll probably make it available for those on our website. So really the format today is Charles Corey Wright is going to open really talking about the general principles and rules around the new consumer duty, particularly from a claims perspective. And he's going to hand over to Jonathan, who's going to really looking at what customer outcomes look like in a claims context. So without further ado, I'll pass over to Charlie. Thank you.
Thanks, Geoffrey, and welcome everybody. And I hope we don't need to worry about fire drill or anything like that. But if you didn't make that sort of announcement, it would then turn out to be necessary. My job is what it says on this slide. Overview of the consumer duty, its purpose and ramifications and guidance as to forthcoming FCA deadlines for implementation. And then Jonathan is going to go through rather more practical ramifications after that. But before we get to the consumer duty itself, we know what it is because we've all read this. It's to protect retail customers and consumers. But it's worth looking at the context in which professional conduct generally may be regulated. Simply to compare, I'm going to get my water. Simply to compare the ways in which the law imposes requirements about professional conduct. All very familiar to all of us, I'm sure, whether we're lawyers or insurers or both. The common law, statute, and regulations and regulatory bodies. Now, this firmly falls into the third of those categories, obviously done pursuant to statute. And we have had, because it's being done through the FCA, a large amount of guidance, which some of you may have had the enormous benefit of going through in great detail, as I have. It's easy to be dismissive about that sort of thing, and it's worth remembering that when judges pronounce in the context of the common law about what professional obligations may be, but don't necessarily do so in a comprehensive way, because the common law works by reference to specific facts and then deducing principles from those facts. People are very often left rather worse off than they would be if those rules were being imposed in a more thought through and generalized way. And the obvious example of this, I'm going to give one analogy before I go back to the consumer duty, it is what happens for clinicians, for doctors, and the way in which their obligations to their patients and to the world at large are mediated through the common law. Many of you who will have experience of clinical negligence type cases will be aware of the fact that a doctor doesn't breach his duty to his patient in terms of treatment if she complies with a reasonable way of doing the job of doctor, i.e. within the reasonable range of possible responses, which all doctors understand as a relatively straightforward process in order to work out whether you've breached your duty or not. And doctors were very, very worried indeed about 10 years or so, maybe a little more ago, when Montgomery, the case of Montgomery came along, dealing with informed consent and information given to patients, where the whole tenor of the Supreme Court ruling in that case was to do with patients being the arbiters of what they needed to know. And that meant that doctors could no longer rely upon their own expertise in terms of what they could say, some of them thought. There has in fact today been a ruling in a case called McCulloch in the Supreme Court, which gives a little extra guidance about this, which is very welcome. But it's worth, rather long aside, I'm afraid, but it is worth bearing in mind that the common law can often be a lot less helpful than guidance given by statutory bodies who are designed for that purpose. So the consumer duty itself, the FCA's original Principles for Business, published in 2018, set out 11 fundamental obligations, the objective of which was to regulate firms in the retail finance market and to protect consumers. Following 2 consultations in 2021, the FCA announced a 12th principle, the consumer duty, whose specific purpose was addressing perceived deficiencies in the existing consumer protection regulations. In other words, put shortly, the absence of the focus or necessary focus on the consumer, the small member of the target for whatever product the firm was concerned with, whether it be insurance or whether it be some financial product or whatever else it might be. The FCA has stated that this duty represents a paradigm shift, requiring firms to go beyond simply acting in a client's interests. They must as well deliver a higher standard of customer care, proactively taking steps to deliver good outcomes for retail customers. Now, all that is very well, but one asks the question, well, how does that work in practice? The FCA wants to apply higher and clearer standards of consumer protection beyond the lesser duties of treating customers fairly. So you still have fair treatment of customers, but it's more specific than that. It builds upon the recent increase of scrutiny on product governance, fair value, and individual accountability. Firms that already comply with insurance product governance and fair value requirements shouldn't need to change much of what they do in these areas to satisfy product and value outcomes. They do, however, need to pay real attention to communications with customers and the post-sales support for them. Now, there are 2 aspects of the new duty. It's as if they're on different axes, one on an x-axis, one on a y-axis. one relates to rules, the other relates to outcomes. And it's important, therefore, to stress that this is not just a question of setting some rules which then need to be complied with. It's also necessary for the firm, those managing the firm, to look at likely outcomes of whatever measures they take in order to ensure that they deliver the outcomes which the rules are intended to ensure are delivered. This represents a change of mindset on the part of the FCA, and it's one that those in charge of the governance of firms need to be aware of. First of all, the cross-cutting rules, rules that cut across boundaries. These are said to be designed to enhance the standards of conduct and assist with achieving 4 required outcomes. They consist of statements of 3 expectations to behaviour to assist firms in understanding and implementing the duty. So the outcomes come next, but the rules themselves are to act in good faith, to avoid causing foreseeable harm, whether by act or omission, to enable and support consumers to achieve their financial objectives. These are, of course, behaviours by the firm. As such, they don't prevent consumers from making decisions which are adverse to their own interests. They simply require them to establish, the firms, to establish an environment in which consumers can obtain relevant advice and materials so as to be able properly to make their decisions. Now, the obligation to act in good faith is an unsurprising one to see here, particularly in the context of the insurance market. Similarly, the obligation to avoid causing foreseeable harm by act or omission. It's worth pointing out that this applies in the context of the consumer duty along the whole distribution chain. So it's not enough simply to look at one's own activities. One needs to look at the mechanism as a whole by which the product is being delivered. We then get to prescribed outcomes. These are outcomes that the cross-cutting rules are supposed to achieve. So as to product and services, they must meet the consumer's needs and objectives and be fit for purpose. As to price and value, there should be a relationship between the cost of a product and the overall benefit the consumer receives from it. As to consumer understanding, firms should provide relevant material in a way that is easy to understand. And as to consumer support, obtaining ongoing support should not be an unduly burdensome task for the consumer. Firms should be responsive and helpful at every stage of the relationship with the consumer. Now, all of that sounds like it's fairly obvious stuff as well. Worth saying that in the context of the insurance market, there is likely to be much more by way of what falls within the consumer support box here than there might be in relation to other firms who are providing only different types of product. It is in the nature of the insurance contract that it may not be called upon until much later, long after the inception of the policy. But if it is called, it may never be called upon at all by the consumer. But if it is called upon, there is highly likely to be a large amount of toing and froing between underwriter or claims, more particularly claims handler, and the consumer, which is where the meat of this particular outcome requirement is going to bite. Sorry, that is a really awful metaphor, the idea of meat biting, but anyway, I hope it's clear what I meant by that. There is a focus on vulnerable customers. firms are required to consider a range of needs in their target market, including vulnerable customers. These could include poor health, cognitive impairment, life events, low resilience and/or capability, such as poor literacy or numeracy skills. The focus here is not so much on a case-by-case scrutiny of individual transactions, clearly very hard to do in advance anyway, and this is all about advanced planning, but as to the design and sale of the products. These must factor in a range of consumer characteristics in order to satisfy the outcomes. And one of the questions that is regularly asked by people saying, well, what do I need to do in order to comply with this? Is brought into play here, because it's a question of how you design what you are bringing to the marketplace, more than, or as well as how you transact with your customer when that transaction ultimately takes place. So a lot of care is going to need to be given. Have I covered the waterfront? Have I covered the range of possible people who are likely to be attracted towards this policy, and have I given them a fair crack at it? And it relates to all these rules and these outcomes requirements apply to the full range of the cross-cutting requirements introduced to, and in good faith avoid causing introduced to act in good faith, causing foreseeable harm, and enable and support customers, those are the ones we referred to before, to be demonstrated in all activities affecting the customers. I'm going to jump forward for a moment. The 2022 guidance, which was essentially the place where the main rules were set out, it's still the final guidance. There's been further postings, further reports from the front, from the FCA, as it were, telling one how to do stuff. But it's the meat of it is still in the 2022 guidance, published exactly a year ago. And can people read what's on that screen from where you are? Not really. Okay, well, what I'm going to do is I will read out the bits that I have highlighted in yellow, which seem to me to be the most important ones, and we can send you the PowerPoint afterwards, and you will see it all in rather more detail. So, the introduction, paragraph 1.1, the duty sets the standard of care that firms should give to customers in retail financial markets. Then, the next slide. A lot of the stuff that I'm skating over is what I've already said. So, important, this section 1.4 of the annex, the consumer duty is underpinned by the concept of reasonableness. 1.5, what is expected of firms under the duty will be interpreted in the light of what is reasonable given the circumstances, including the nature of the product or service being offered or provided, the characteristics of the retail customer, and the firm's role in relation to the product or service. Then, next, the scope of the common duty, retail customer scope, that's what we're concerned with here. The specific wording in relation to insurance is as follows. For insurance, the scope follows the position in the Insurance Conduct of Business Sourcebook, ICOBS. The duty does not apply to reinsurance, contracts of large risk sold to commercial customers, or other contracts of large risk where the risk is located outside the UK. Nor does it apply to activities connected to the distribution of group insurance policies or the extension of these policies to new members. That was all I was going to focus on from that guidebook. So, just to go back in the slides to, sorry, I took myself slightly out of order because I thought it was better that way. On the 28th of June, so a couple of weeks ago, the FCA published 10 key questions in the context that the regime was going to be brought into force on the 31st of July, in other words, a month later. And these are divided, I've divided them up into 3 parts. First of all, as to products and services. Are you satisfied your products and services are well designed to meet the needs of consumers in the target market and perform as expected? What testing is being conducted? We're saying these are questions that might well be asked by the FCA of any insurer if they were wanting to satisfy themselves of compliance. So it's worth bearing these in mind. 2, do your products or services have features that could risk harm for groups of customers with characteristics of vulnerability? If so, what changes to the design of your products and services are you making? 3, what action have you taken as a result of your fair value assessments? And how are you ensuring this action is effective in improving consumer outcomes? That's to do with value as opposed to do with the vulnerability. 4, what data, management information and other intelligence are you using to monitor the fair value of your products and services on an ongoing basis? But then there's 4 questions relating to communications and customer support. How are you testing the effectiveness of your communications? How are you acting on these results? How do you adapt your communications to meet the needs of customers with characteristics of vulnerability? And how do you know these adaptations are effective? What assessment have you made about whether your customer support is meeting the needs of customers with characteristics of vulnerability? So it's the same series of inquiries. What data, MI and customer feedback is being used to support this assessment? Have you satisfied yourself that the quality and availability of any post-sales support you have is as good as your pre-sales support? Slightly curious question that, because it implies that the pre-sales support is the benchmark by which your post-sales support should be given, but in fact, neither might be as it should be, but leave that aside for a moment. And then generally, do individuals throughout your firm, including those in control and support functions, understand their role and responsibility in delivering the duty? Have you identified the key risks to your ability to deliver good outcomes to customers and put appropriate mitigants in place? Now, if as a firm, insurance firm, or whatever, any other firm, you can answer those questions in a positive way. In other words, yes, I'm satisfied by myself and these things are fine, then by the lights of what the FCA is saying, you should be okay. I suspect some of those questions will be harder to answer than others, but my own feeling is that demonstrably being able to show that you've sought and obtained feedback from those who are in communication with you about buying your products would go a long way towards satisfying an awful lot. I was asked and have also to give guidance as to the implementation dates. As Jeffrey's already said, the implementation date for products on sale or renewal now is the end of this month, 31st of July. For those products that are no longer available, what they call closed products, it's the 31st of July 2024, which sounds counterintuitive until you realize that they're prioritizing ones that are still available for use. There will, of course, be ramifications in relation to past products where the insurance is still ongoing or where claims might still be able to be made, but they're wanting to deal with the they're wanting to deal with the low-hanging fruit first. That's all I was going to say. I will hand over to Jonathan And then if anyone has any questions at the end, we will deal with them together.
Thanks very much indeed, Charlie. I'm Jonathan Drake. I'm a partner at DWF. I specialise in insurance and reinsurance regulation. I have a background in an in-house lawyer, both at the underwriting side of the business and also more recently in the broking side of the business. Someone once said to me, which side of the fence do you prefer to be on? Was it the underwriting side or the broking side, or were they both equally on the side of the devil? So I'm not actually going to answer that question for you today. But what I am going to hopefully answer for you today is just really looking at some more detail around the consumer outcomes, and in particular, the consumer support outcome. And as Charlie's given you the overview, the consumer duty is one of the few regulatory areas where all of us within the insurance industry can pat ourselves on the back and say, actually, we're ahead of the game here. Because I sit in a part of DWF, a law firm, where we advise other regulated firms, wealth management, banks, a whole range of FCA, PRA regulated firms, and we are ahead of the curve. Congratulations to us. IMD, IDD, PRA rules, the FCA handbook rules, all on insurance actually mean, and as Charlie also mentioned, that if you're already complying with some of the requirements in the FCA handbook, you're probably up to speed quite well with some of the consumer duty requirements. There's a large but in all of this, however, and the but around that is in relation to the consumer support. So that's really the bit, obviously, that comes after the policy's been sold. And as I mentioned, also Charlie touched on as well when he was talking about, it's like counterintuitive that pre-sale policy should be equally as resourced as post-sale on the claims side. I think it's probably fair to say that traditionally the underwriting side of our business has been the one that has attracted more of the regulatory attention and also more of the, I think, under the front end interest. The FCA has been very, very clear. You've got to demonstrate how you're providing the customer support as one of the consumer outcomes. And that means putting as much focus on your post-sales activity as on your pre-sales activity. You've gone so far as to say you should be spending the same amount on post-sale as pre-sale. So what does that mean for those of us who are handling claims? That means, in theory, we should be turning around and saying, well, okay, we need to be equally as resourced on the claim side. So I wanted to frame that context first before I look in a little bit more of the detail. But it's important, as I said, to understand that from the FCA's viewpoint, the claim side is just as important as the sales side. And in reality, of course, it's for our customers, for our policyholders, it's more important. It's the point at which our product delivers. It's all very well having a sexy underwriting front end or selling your product through an aggregator. But if your product doesn't deliver at the point of claim, the product doesn't have the value. Now, again, as Charlie mentioned, the FCA has obviously been doing a lot of work about fair value assessments. What's the claims ratio? What's the expense ratio? What's the cost against value? In reality, what really matters, I think, is when we deliver on the claims side of that thing. So, framing those bigger points, the first thing I wanted really to talk about in a bit more detail was the fact that the FCA is expecting all insurers and also intermediaries, anyone else regulated in the insurance distribution chain to be able to demonstrate how they are providing customer support. And that starts at the top. The board is responsible for making sure that the strategic leadership leads to the successful implementation of the consumer duty throughout the insurer, throughout the broker. That work, the initial assessment should already have been done. Although the rules themselves come into force on the 31st of July, the board assessment piece should already have been carried out within your firms. And you do it once, you then go on to do it annually at your board level. So you have to assess whether or not the firm is delivering good outcomes for your customers. That's the task. Underlying that, and to prove that, and a number of people have already mentioned to me that the evidence base, Jeffrey, for example, made the point to me that the evidence base for this is actually one of the difficult areas that insurers are finding themselves in. But the FCA is going to come to your firm first, if there's a consumer duty issue, and say, show me your board assessment, and then show me how you got to your conclusions. What's the evidence to back that up? So yes, your directors can sit in the board meeting, say we're happy with the good outcomes, but below that, you're going to have to be able to demonstrate how you reach those conclusions. So that will involve underwriting, obviously, on the front end, consumer understanding, target market, fair value assessment, but it'll equally engage with you on the claim side of the practice. What's our data? What's our MI? How many complaints are we getting? If we're getting some complaints, are we doing a root cause analysis on those? If we handle a lot of claims through call centers, for example, are we monitoring call response time, open to close case? All that type of data is going to underpin your board's overall assessment. So you've got to make sure that if you're feeding into that process, if you're part of that process, if you're responsible for that process, if you're on the board, then making sure you're preserving that evidence, making sure you can support those conclusions. For those of you that individuals that are under the SMCR and that regime, you may have prescribed responsibilities, you may be certified individuals. Consumer duty is going to flow down to those areas as well. If you've got a statement of responsibility, for example, that will feed into the consumer duty. Internally, how you incentivize your staff, how you reward your staff, bonuses, etc., performance reviews, all of those should be kind of referenced, include reference to the consumer duty, because the FCA is going to want to understand how you've gone about making sure that the person handling the claim is being rewarded in a way that results in good outcomes for the consumer rather than fast turnover of claims, for example. And then in the way in which you go about doing your board assessment, if that involves using your compliance function, your internal audit function, your risk function, for example, if those are part of the assurance process, then again, evidence. Just make sure that if you're relying on your internal audit to say, yeah, no, we're meeting all our claims targets, we're meeting all our response times, etc., make sure that that evidence base is available and cogent as well. So, some more detail. What does the duty mean in relation to your claims handling? So, obviously, Charlie mentioned about the requirement to avoid foreseeable harm to policyholders. Where might that arise in the claims process? And a number of these examples are ones that the FCA have given, either from their guidance papers, from some of their thematic reviews, some of the response papers. So, consistently poor, excessively slow service. ringing a call centre to try and make a claim, not being able to get through for a couple of hours, being bounced around internally into another area within your firm, for example, or alternatively, writing in an email to a claims helpline, not getting a response back for a month. That obviously plays into the second point about under-resourced customer helplines, and this whole point about the focus of insurers historically being on the policy sales side rather than the claims side. Although I haven't actually mentioned it here, there's a great word that the FCA loves, and that's sludge. So they talk a lot about getting rid of the sludge. And what does that mean? The sludge are those friction points in your policyholder's interaction with you, whether it's pre-policy sale or post-policy sale. It's that difficulty in dealing with insurers or with brokers that they're expecting you to try and minimize. Now, ironically enough, in the pre-sale side, actually, what the FCA has found is there's not a lot of sludge because insurers want people to have a very slick run through. If you're buying a policy through a website, then click, 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 you're done. There's your policy, boom, done, 5 minutes. The customer doesn't think about it very much until they bought the policy. Okay, then I'm going to think about it afterwards. Whereas the FCA says post-sale, a lot more difficult than that. The claims process is difficult to navigate. How do I find the right place to make my claim? Where do I find my claims number? Got a policy. Okay, my IPID, not very clear on my IPID. I've got a policy booklet, where's the helpline? So the FCA views those sorts of things, you know, making it just being a bit difficult to make the claim. That's the sludge that they're very keen on getting rid of. And the last bullet point there, where how to access support or poor handoff processes, including where third parties involved in its provision. Actually, as we know, the insurance industry is terrible for having long distribution and support chains. You might have sold your policy through a cover holder. The cover holder might have a TPA arrangement for claims, might have to come through a broker and the intermediary. You might have 3 or 4 parties in that chain between the insurer at the top end, the sales bit, and that means that sometimes the claims process is a bit fragmented, it's a little difficult, it may not match up. The FCA is very aware of that. They don't like the general insurance distribution chain model in the way in which it's typically been operated over the last 30 years. It views a lot of the lengthy chain as being a barrier to customer support and also having a negative impact on the customer value as well, because everyone's taking a slice out of the premium. Everyone's, you know, your cover holder's taking a commission, you've got a TPA being paid that flat fee. So the FCA has been very focused on this and will continue to be focused on this as well. So what does the FCA actually think that you should be doing? What does good claims handling look like? It looks like providing support that meets the needs of consumers throughout the life or products of the service. Well, that's motherhood and apple pie a bit, but nonetheless, it's reinforcing the point that the assistance you get pre-sale should be the same as you get post-sale and claims. Ensuring that it's easy to find where you make your claims, that's the converse of not being able to do that. And again, make it as easy as possible to be able to get the claim through. And we'll look shortly about what that means in the later part of the claims process. Some examples about what really is poor claims handling process. So they gave a specific example. They've been into one particular insurer that had said, we want you to send us hard copies. And actually, we prefer if you send us the originals, that would be great. And also, you've got to send them into this postal address. we won't accept PDFs. So that's probably quite an extreme example. I doubt whether many organisations that are handling consumer duty type claims these days will be doing that, but nonetheless, it goes to make the point. You should be making your claims processes as easy as possible. Now, I mean, this isn't a blank season and open checkbook for claimants to make any claim they feel like and then not being able to support it. It's just how you ask your policyholder and claimants to evidence the nature of their claim should be easy for them. And there is going to be, as Charlie also mentioned, a very big focus on vulnerable customers. The FCA about 2 or 3 days ago updated its guidance for insurers on dealing with vulnerable customers. There's a lot of stuff in there about how you need to be thinking about identifying groups of policyholders, claimants that might have potential issues. You don't have to have a process in place that identifies every single person as being a vulnerable policyholder, but you do have to have your claims staff sufficiently trained to be able to recognise potentially a vulnerable customer, signposting those customers for other help. If they're financially vulnerable, they're having a problem paying the premium, for example, you're not going to be just automatically cancelling their policy after one missed premium. The FCA, and by definition, and haven't talked much, and I don't have much time to talk about FOS on here. I will mention it a bit, but both the FCA and FOS are not going to take a bit of a dim view of someone who emails you saying, listen, I can't pay my premium, sorry about that, and you automatically cancel the policy. That is not going to go down well. The last point is really more again, it's kind of the overarching rule around making it as easy as you can for your policyholders in lodging their claims. So I said I'd touch a little bit about complaints and FOS, although that was slightly outside the remit. At the moment, most insurers are already collecting MI around their complaints. Where are complaints coming from? What's the complaints about? Doing a root cause analysis. So should be carrying on doing all of that and feeding that in to your customer support and also your customer understanding as well. But it's going to get more tricky as well in the new regime around complaints, because from 31st of July onwards, if you see a number of complaints from same area perhaps, rather than, and I'm picking off is not sounds slightly pejorative, but dealing with complaints individually in isolation is not going to be an acceptable position to take if you recognise that there's a common link between all of those complaints. So you have to think about, okay, we've got a bunch of complaints from the same underlying cause. Should we actually think about some form of redress? Should it be a redress scheme? Should we be addressing all the policyholders because we've recognised that there's an underlying issue, either with our policy, maybe, the way it was designed, or it may be in the way in which we dealt with the claims. Can be pre-sale, could be post-sale. There's going to be an obligation on all insurers to consider early redress. And the one bit of the consumer duty and the guidance that I think I was really surprised about was this bit, which was the FCA said, if you're getting similar FOS complaints, adjudications, findings, and you recognise that they're kind of the same, but you just wait for each of them to get decided, rather than dealing with them, as an early redress scheme. If you're not looking at them as a whole, if you're dealing with them individually, even though from the same root cause, that could actually amount to bad faith. And that's the phrase that the FCA uses. And that's really, really, really surprising. That's an interesting turn of phrase for them. It's a slightly odd context. I don't know why they've become so excited about this particular area, but they use the phrase bad faith. And they also stress the fact that that would be in the context both of the firm itself and the way it operates, and also in relation to the relevant individuals responsible for that. So it's a really sharp prod in a slightly unusual place around the consumer duty, because I was not expecting it to be in the complaints focused areas. I thought it might be somewhere else, but that's the area that they've chosen to highlight. So don't want to be scaremongering here, but it's just do the things that you're doing in relation to complaints anyway. Pay more attention. And if you do see an underlying cause, root cause from your RCAs or whatever analysis you do, be prepared to address those at an early stage. And don't be, I think past behaviour may not be acceptable in this regard going forward. So I think care and attention is required around the complaints area. One of the questions that I was also asked to address, and that's come up in a few fora, is actually when we get to the sharp end of a claim and lawyers are instructed, or alternatively, if in-house lawyers are dealing with claims, how does the consumer duty interact with external law firms and also potentially internally as well? So apologies, a little bit of regulatory background and overview. It's important to emphasise law firms of themselves are not subject to consumer duty. There's a very arcane reason for that. Basically, they're exempt. Law firms are not subject to the general provisions of the Financial Services Markets Act. Lawyers aren't regulated under FSMA. We're exempt because we have a recognised professional body, the SRA. So law firms themselves don't have to comply with the consumer duty in relation to their customers or any clients. Now, a number of insurers have been approaching the consumer duty in a way that is requesting of their law firms to respond to questionnaires, to respond to requests for detailed information about how those law firms are going to deal with the consumer duty. How are you going to comply with the consumer duty? The strict legal answer to that question is, it's not the law firm's consumer duty, it's the insurance. It's the insurers or the brokers or the cover holders' consumer duty. You tell the law firm what they should be doing. They should be doing that for you if it's within the terms of their retainer or their SLA. But strictly speaking, the law firms themselves are not duty bound to implement the consumer duty requirements. And if you think that through logically, it makes sense, because for an insurer, if you have a book of travel business, for example, travel insurance business, consumer duty comes in, you've got to get good outcomes, not cause foreseeable harm. The response to a policyholder that may be injured overseas in a difficult jurisdiction, the response to a claim under that policy, and lawyers may be involved in that, is going to be very different to the response that you'd have to make, say, if there was a fire claim on a small commercial premises. That might still be subject to consumer duty, because as Charlie's already pointed out, large risks aren't covered, reinsurance isn't covered, but ICOBs is. So you're going to have small businesses, commercial customers that will fall within consumer duty requirements. So now, as the client, the insurer may well say to the law firm, under your retaining with us, under your SLA with us, under our panel rules, you've got to do X, Y, or Z. That's the way in which this relationship actually operates. But as I say, I wanted just to be clear on the fact that it's not the law firm's obligation to comply. It might be a contractual requirement that they do that, and it's also a little bit of an ask to say that there has to be a bit of give and take around this, because some of these areas are quite tricky. It's outcomes based, it's not rules based. As we've seen, the whole thing is good customer outcomes. Now that's difficult. If you ask a law firm to say, what are you going to do to make sure that you meet the consumer support requirement, that's a tricky request for a law firm. How are they going to respond to that? Now you might say to them, are you recording calls with our customers? Are you recording response times? Can you tell us how long it's going to take you to handle a claim from open to close? That's the sort of information that the insurer may well need to be able to evidence its compliance with the consumer duty. If you remember, right at the beginning, I was talking about the board doing the annual assessment and having to evidence that. So law firms externally may have to be in a position to give that type of information. So there's got to be a kind of flexibility in the relationship, I think. Now, I mentioned the second bullet point there, which is that separately owned claims handling firms, again, may be subject to consumer duty requirements if they're FCA authorised. Now, of course, some law firms have separate claims handling arms. Some insurers have separate claims handling operations as well. Under the IDD, claims handling on behalf of insurers is an exempt activity. So if all the claims handling firm is doing is purely handling claims on behalf of an insurer, then you're not required to be FCA authorised. It's the FCA authorisation that will bring you within the scope of the duty. So there's quite a few moving parts in the legal landscape about how to deal with these issues. So, having dealt with all of that, what is it actually that we all should be doing to make sure that actually we're up to speed with all of this, that we're doing the right things? In reality, law firms should be making their claims handlers, whether it's their solicitors, whether it's their paralegals, whether it's through their claims handling on. In reality, you should be giving some basic training around the consumer duty, because you're going to intersect with that in your claims handling legal life, and put it like that. And as I've been going on interminably, evidencing what you're doing around that is probably going to be quite important. From an insurer's point of view, when you get met with a challenge, what are you doing? Making sure that the customer support outcome is being met. One response to that is we are working with external providers, including law firms, claims handling firm, who are training and have trained their staff, their claims handlers, in relation to the requirements of the consumer duty, and we can evidence the fact that we've required them to do that, and that they can provide us with the evidence to back that up. So I think having training around that important, and I think that's generally important. And I've been working with a few insurers just in internal training programs, looking at what level of detail do we need to do for this, and there's not a lot of right or wrong answers around this at the moment. Again, it's outcomes based. The FCA is deliberately not taking a rules based approach here. They don't want to have to prescribe rules. And the reason, the policy reason, although I don't know if they've come out and said it, the policy reason behind the consumer duty is because they were having to set rules for all the different sectors, regulated financial services sectors. As I mentioned before, insurance, we're ahead of the game, but that's a result of the IDD and IMD. So we were forced to deal with these issues, you know, looking at treating customers fairly, fair value in a way, through those IDD and IMD requirements. In other regulated areas, it was not the same. There was nothing like those sorts of rules, product governance rules, target market rules. Those were not there for those areas. So the consumer duty here is a broad church that we as an insurance industry are having to live within. And in some areas, as I mentioned, we're ahead of the game. In other areas, I think probably we need a bit more, bit more activity. So I think that, as I say, we've kind of galloped through that a bit, but I wanted to really throw open to the floor for you here, because I think because these are outcomes focused, it's very difficult to give you guidance. And as Charlie also mentioned, the common law can operate in a very narrow way. The rules-based environment that we're all dealing with now historically has been clear. ICOBs, are you responding within X period of time? Have you given an EPID, etc.? This is different. How do you know whether or not you're giving a good customer outcome? How do you know if you're giving appropriate customer support? And the answer is you can best inform yourself actually reading what the FCA thinks of these questions. Whether or not you agree with them, that's a different matter, but they've given, again, as Charlie said, lots of guidance around this. So, so with that, I just really wanted to kind of open the floor up a little bit for questions. And as I say, we've galloped through this actually because we just thought we could have talked for hours on these subjects, but we chose to give it a bit more focus for you, hopefully. But obviously, happy to take any questions.